Please. Welcome to the 9th meeting of 2013 of the Rural Affairs, Climate Change and Environment Committee. Members and the public should turn off their mobile phones and their Blackberries, as leaving them in flight mode or on silent will affect the broadcasting system. Agenda item 1 is a decision on taking business in private, and the first item on the agenda today is for the committee to decide whether its consideration of its RPP2 report should be taken in private at future meetings. Are we agreed? Yes. Thank you very much. Agenda item 2 is subordinate legislation, and it's a consideration of 2 negative instruments as listed in the agenda. One relates to Water Environment Drinking Water Protected Areas, and the other to the Wildlife Countryside Act of 1981. Members should note that no motions to annul have been received in relation to these instruments, and there's been nothing referred to us by the Sublege Committee. I refer members to the paper and ask if the committee's agreed that it does not wish to make any recommendations in relation to these instruments. We're agreed. We're happy about that. Thank you. And now on to agenda item 3, a review of the agricultural rent review procedures of Scotland. And today's committee will take evidence on the Rent Review Working Group's report on the group's recommendations to the Tenant Farmers Forum and the Scottish Government. I apologise for the slight delay in starting, gentlemen, but I'm sure we'll make up for it. I welcome the group here, Henry Graham, the group chair, Ian Duncan Miller, John Mitchell and John Ross. Good morning, gentlemen. I wonder if anyone from the panel, perhaps Henry, had a few words to say at the beginning. If you wish, it's up to you before we come to questions.
I think that would be good to start off that way. You know, you've all had the background papers, and we started off about July last year at the request of the Tenant Farming Forum, you know, to actually have a look at, you know, the rent review, how it was actually working. And there were some very specific questions that we were asked to look at. And, you know, therefore, you know, the report is based very much on, you know, these specific questions that we were asked to, you know, to have a good look at. We thought it was sensible to, you know, to ask, you know, all the concerned parties just to get their thoughts on, you know, the whole subject of rent reviews and how rent reviews were carried out. And we did that, and it was good to see the response. We got over 100 responses to the questions that we asked that would help us answer the questions that we'd been asked. It was very interesting to see the comments, because they were coming from landlords, they were coming from tenants, and they were coming from, you know, the different agents that were involved. And there was a real mix of information coming through. And one of the areas that we found, you know, interesting was that in a large number of rent reviews, there was absolutely no problem at all. You know, there was a tenant that had been there on a secure tenancy for some time, a landlord with a resident factor, and the rent reviews were carried out in an amicable, professional way. Maybe not the way that is described so technically in some of the acts, but, you know, the rent reviews were being carried out, and, you know, an end result identified that was sensible to both. There were, you know, some replies, you know, showing certain areas of concern of how rent reviews were carried out, and in the main, that tended to be where the resident factor wasn't carrying out the rent review, and professional agents had been brought in, you know, to actually carry out that rent review. And that was where, you know, some of the issues that came back to us from that consultation were reported. What we did tend to find was there had been quite a number of rent reviews not carried out for actually some time. Because of, you know, maybe foot and mouth, weather conditions, BSE, And therefore, the rent reviews that were being carried out relatively recently hadn't had one prior to that for some time compared to the normal pattern. And therefore, it came through quite strongly that there wasn't the understanding of what should actually happen in a rent review if you were following the whole system, pretty technically. So that's why, we identified in our recommendations the need for, an improved understanding. And in the report, you'll see that, there's three major areas. One, the practitioner's guide, which we felt was absolutely crucial, and what actually happens south of the border, how to actually carry out a rent review. And secondly, the need for, when the rent review is intimated to the tenant, rather than just this notice to quit, an explanatory note to be sent out at the same time about what was actually going to happen, at a rent review. And thirdly, a layman's guide, just, very, to really summarise, to summarise what is quite an actual complex subject. So there's these three major areas that we identified that there was a real need to, to carry forward, really around the area of improved understanding of the whole subject. Second area was the improved, actual knowledge of what was happening in other rent reviews, and therefore the need for a rent register that everybody could actually, pay attention to for these secured tenancies and limited duration tenancies. So we felt that was really crucial, the actual need for a rent register to be held centrally and administered so that everybody actually had more information on how rents had been identified for certain types of farms and in different regions. And, the third area was, around if there was some type of dispute, improved dispute resolution. And we did find that in the reports coming back to us that the land court was held as a trusted body, but the land court procedures actually took quite a long time and were costly. And that's why we looked at this area of dispute resolution. Firstly, to see if there's ways of improved case management in the land court to streamline, that system, make the whole process quicker and faster and cheaper. But also the other areas of dispute resolution that we've actually come forward with in the report. It was around, some sort of short form arbitration, which would speed up the arbitration process if the different parties identified that arbitration was the route they wanted to go down. And the final one was expert determination, where in commercial practice, this expert determination is used, in the main for rent reviews. And again, we felt strongly that that was an area that should be explored further. So that's a kind of summary of, what we were asked to do, the evidence that we asked for. We didn't come up with anything completely out of the blue. That wasn't our task. It was what we were hearing coming forward from, the different reports that came forward to us, and then to try and summarise that in recommendations that would actually improve the process. Because there's some areas that we did feel was still, and I've referred to it previously as a black art, and to try and get some science and methodology behind it to actually, make that less of a black art so that, everybody can respond to it.
Thank you very much for the introduction. Nigel Donne is going to kick off with our first general look at the question.
Thank you, Convener, and good morning, gentlemen. It's good to see you here. Thank you for the introduction. You led Mr. Graham directly to my question, because when I looked at this, and I come to this as an outsider completely to what we're talking about, I went back to sort of chapter 1 of the elementary economics book, which suggests to me that the value of something which is productive is dependent on how productive it is. And therefore I'm surprised to find that we seem to be in a position where you're suggesting that the productive capacity of a farm is not directly relevant to its rent. And I would have thought that the converse should be precisely the case, that the productive capacity of a patch of land and the assets on it ought to be surely the very starting point for any rent. Could you explain to me why that's apparently not the case?
Ian, do you want to answer? Sorry, we'll move the questions
Indeed
around
so.
if that's okay.
The microphones are handled automatically.
All right. I think Ian might be, best equipped to answer that one.
Please do.
Thank you, Chairman. The question really revolves around what is something worth, and you're quite right, Mr. Don, in pointing that out. But as in all things, the market reflects that. So what farmers are prepared to pay in rent for other pieces of land does determine that. And we had evidence given to us that in the cases where farmers were offering for rent for land in other capacities, either open market, auction, or even privately, they made an assessment of what that land was worth to their business. In other words, what could they get off it, what profit could they expect from it, and therefore what rent were they prepared to pay. So the system of using the market value inherently has that process within it of what the individual farm will be able to produce. The other issue which came to us quite clearly in terms of the evidence was that if you take the volatile life in which we live in agriculture today, where commodity prices do go up and down very considerably from year to year, then you could see rents going up and down very considerably in terms of following a budgetary approach, which is what the suggestion that you make. So if you take the budgetary approach, then things vary very considerably. If you take the market approach, then the things are leveled out, and you produce a more level, even process. If things are improving, it's upwards. If things are not improving, it's perhaps downwards or steady. And the other thing to consider too is that by following a budgetary approach, there are a number of other issues which will come up. For example, if you have a budgetary approach, you first of all got to work out what is the income which is divisible between landlord and tenant, and how do you work that out. You can do budgets based on the way the tenant runs the farm, or if you take the model of the 86 Act in England, you take the model of what would the hypothetical tenant do with that particular piece of land. And immediately you open up a whole discussion as to what is the best way to run that particular holding. There are other issues of environmental schemes, there are issues of diversification, and there is a whole discussion to be had within that area as to how you would work out what the budget should actually be based on. And having got to your end point, you then have to say, well, how do we actually make the split? Now, in England, there is a sort of rule of thumb, it's 50-50 between the landlord and the tenant. Nobody was able to explain to us why that should be, upon what it was based. And actually, if you then step back from it and say, well, what does it achieve? Is that going to achieve a better result than what the Section 13 of the present Act does? Then we were not persuaded that it would, because the market itself actually determines what the rent payable by farmers for that piece of land would be, and that follows their ability to actually make the calculations and to make profit from that enterprise. So it was our view from the evidence led to us that by going down a primarily budgetary approach as the first way of calculating would not improve what is there as a model, a framework at the moment. And I think the other important thing is that we have got guidance from the Court of Session that actually having done the calculation, however you do it, there is the important point: you must stand back at the end of the process and say, well, actually, have we arrived at a sensible position? Is the rent we've arrived at here a sensible answer? And the budgetary approach will be done in support of the market evidence. And if you do that, then you actually come to answer that final question, that very important question: have we arrived at a sensible answer? So while it's not in the primary framework, it is there. What will the unit support is there as part of the process and arriving at what the market actually is paying for a piece of land.
Indeed. Okay, so we've got to chapter 2, as it were, of the economics book, which says, never mind your costings, the market will sort it all out, which I endorse and understand and respect. How then do you work in a situation where there is no effective market? I'm sticking at basic economics here. Sorry, other people will want to pursue the detail of this issue, but if there's no effective market in an hereditary farm, then surely productive capacity is the benchmark that you have got. You can reasonably compare with other farms that you might expect to have the same kind of productive capacity. That's for experts, not for me. Surely that's a better comparison than with a hypothetical market which doesn't exist.
I think behind your question is a quite interesting point. Yes, there are not new 91 Act tenancies, secure tenancies being offered on the market, and that is a fair point to make. But there are other forms of tenancies being offered from which we can make the adjustments and calculate back. The other point is that there are a number of 91 Act tenancies in Scotland which are being adjusted and are being agreed and reviewed on a regular basis. And the point of the rent register, which Henry Graham referred to, is that information is known. And while it is not an open market in terms of an auction for a cow or a heifer or whatever in the marketplace, it is still the marketplace in operation, and that knowledge should be freely shared and available between all parties. So the market is actually there and it is operating, and that knowledge should be available freely so that we understand how the market is working.
So you would accept that a perfect market requires information to be available, and the implication of what you've just said, if I've heard you right, is that maybe that information isn't available to both parties.
I think it would be fair to say at the present time that information is not equally available to both parties.
Thank you.
I guess, and then Claudia. Yeah.
Yes, thanks, Convener. Just to pick up on that final point that you made, I had been going to perhaps bring it in later on, but we see from the response from the NFUS that it came to the conclusion that further amendments in the law on rent reviews was required, and that the NFUS believes that the practitioner's guide recommended by the group should be a mandatory code of practice, and the voluntary register with information on rent should be compulsory. What was the group's view on that, given that given the comments that you've just made with regard to rents?
John, do you want to have a shot at that one?
One of the issues that we had to consider was whether if we had recommended a change in the legislation, which a number of groups would have liked to have seen us do, then that would have left a considerable amount of time before the changes would be tested in a court and would become enshrined in law. The NFUS, in their submission, they felt that there should be more teeth put into the code of practice. My understanding is that the Tenant Farming Forum is now busily engaged on drawing up the various parts of the recommendations that we made. But on the wider picture, we were not persuaded as a group that there was a need for significant change. It was actually the way in which the current Act operates that needed greater transparency. I am a tenant farmer, and I have various landlords, and one particular landlord actually has operated in a very transparent way over the years, and that has meant that there has never been a significant problem in negotiating a rent under the current legislation.
But clearly,
could I maybe just follow that up, because you're asking the question about the rent register being mandatory, and like as I mentioned previously, we weren't coming up with our own thoughts. It was very much what we were hearing, and there was from the tenant side, there wasn't the real interest. When we asked the question, would you be happy if all your membership had to provide, the information for a rent register, and that was really why we were saying, that should be voluntary, But if it's working, then there'll be more and more people wanting to actually contribute to that rather than it actually being mandatory, because we weren't hearing from the information and the evidence that the audience wanted it to be mandatory.
And clearly, the transparency that has been called for would be preferable. But clearly, if the voluntary register was working, then that would be all well and good. And presumably in the future, if it wasn't working, then making rents information mandatory would be a solution.
Claudia Beamish.
Thank you, Convener. Good morning to you all. Could I take you back briefly to the issue of the productive capacity of a holding in relation to the Scottish Tenant Farmers Association's comment about that, that they, as I understand it, would want to see that as part of legislation as a factor to be taken into account in the land courts. And I wonder if you could comment on that from the perspective of your findings.
Could I maybe start and maybe bring John and Ian in afterwards? Going back to the actual productive capacity, I think what we were if we look at what's in place just now, first of all, you look at what the market is actually saying. If we can get the rent register really going well, then there's a lot more transparency, a lot more information to actually feed in for what's happening on secure tenancies, as well as what's happening in the open market. And we all realise the open market is not there because there's no new secure tenancies being made available. So therefore, the existing secure tenancies that are being rent reviewed, if we can get that information onto a rent register, then that is a lot more useful information to actually use. After that, in the existing legislation, there's still the requirement to look at, is that rent reasonable? Is that rent fit for that unit? And that's in the existing legislation. So therefore, in assessing if that rent is actually reasonable, you can actually allow the budgetary process to actually come in the existing legislation. So if you're looking at the whole package, the existing legislation allows all that to happen at this point in time. In the existing legislation, what is referred to as economic conditions. And that is if, say, when I'm selling some lambs this year, the price has dropped by 25% compared to last year, and the rent reviews that have been used as comparables, we're using that past information, then you can use the new information for economic circumstances. If we look at productive capacity, that's quite a different subject to economic conditions. So you're actually moving quite a long way. And I've been a banker for about 30 years, and I've seen a lot of different budgets, with productive capacity. And that's just the output. There's no consideration of any of the costs in just using productive capacity. So you're actually limiting, the actual information that you're using if you just look at productive capacity. So that's why we had concerns about productive capacity. It's just the output. It's got nothing to do with all the other costs in running that business.
Tina, could I just come back briefly on that? Could I ask you then, Mr. Graham, why, in your view, or the members of the review group, could you shed any light on why the Scottish Tenant Farmers Association would want that used as a factor? I'm listening to what you're saying about the inputs and everything.
I think they've maybe referred to what happened south of the border in the 1986 Act tenancies, where negotiations took place and productive capacity and earning capacity was actually brought in at that time. But as part of the negotiations with other parties at that time, the tenancies then became not secure They were only for 3 generations, which is quite a major change, you know, for what we've got here in Scotland. You know, that's maybe why STFA are referring to productive capacity, because that's what's in that actual act south of the border. And as Ian mentioned earlier, we got information from both sides of the border, and we tended to find that the 1986 Act tenancies in England, the rent reviews were actually higher than what's happening in Scotland. We weren't making a lot of noise about that, but it just maybe tends to illustrate how if you just use an output part without looking at the costs, because farmers tend to underestimate costs. I found that over the years. They like to think about what we get for a fat beast or what we're getting for our grain this year, but forget a bit about just what the actual costs are in total. And I've got concerns about just using just that output productive capacity area in these rent determinations. Ian, do you want to follow that on?
Thank you, Convener. I think inherent in the question is a slightly dangerous assumption that it's a question of either or. And I think, I know, but it's maybe seen that way in some cases. And I think that what we found in the evidence that we received was that actually you've got to look at the whole picture of the rent of a farm. It's not just about the budget. It's not just about what the comparables. It's about the whole package. And I think it's got to be understood clearly that actually comparables, when used properly and adjusted properly, and that's very important, actually do inherently in the background take account of the capacity of individual farms. I mean, one of the things that we use to judge the comparable holdings is, for example, the Macaulay soil type, and various other factors as well. But that's an example where the type of soils on the farm would give an indication of the type of crops that could be grown. And so therefore you make that, and that gives you a bit of a handle on the capability of that particular holding. So these comparisons are being made within the present framework. And I think that to change the framework, as we were asked to look at, we had to come back with something which was better than the present framework. The present framework is pretty well understood now and how it works. And it does actually, when you dive down into it and really use it on a day-to-day basis, it does take account of all these other issues about the budgets, about how the farm was used. It does also compare one farm to another. In other words, how is the market itself operating? And I think that's important, you take the whole picture. And the Section 13, as we now have it clearly defined, is a framework which is clearly workable and does work. And the other thing that we've received in evidence, maybe pertinent at this point, is that the evidence we received largely pointed to the fact that it was not the framework upon which the rent is calculated that seemed to be the issue. It was the process, and the process of actually the discussions that led to the point of having a negotiation around rent.
Just, Convener, very briefly, just to clarify, I did make the point that it was a factor, not that it was the deciding factor.
Graham Day.
Thank you, Convener. I want to specifically look at Section 13 in relation to the Moonsey judgment, because in the judgment it was noted, and I want to get this absolutely right, Section 13 of the Agricultural Holdings Act, it was noted that the inadequacy of the drafting of Section 13.1 had already been acknowledged in another case. It went on to say that literal readings of subsection 13.3 and 13.4 would produce an absurd result, and it called the draftsmanship of the amended section inept. Given that, what was the actual basis for your group concluding that the section did not need any further amendment, when clearly learned legal opinion disagrees completely?
John, do you want to?
I can answer that. Or I will attempt to answer that. Section 13, as adjusted, it was first adjusted by the 2003 Act. Unfortunately, so far as subsection 1 is concerned, there was an omission in that the requirement to give notice 1 year before a rent review date was taken out when Section 13 was adjusted. That was initially dealt with by a land court application, and albeit the words no longer existed post the 2003 Act adjustment, the Land Court said to make common sense of the legislation, we will proceed as if they are there. And that was subsequently corrected in further legislative reform to the 2003 Act, and the requirement for notice has been written back in. Any new legislation will be the subject of, or potentially be the subject of, judicial interpretation. And the other subsection that you took us to was subsection 4. Lord Gill certainly does not like the way in which the words in the statute now read, but he has given guidance as to the way in which those words should be interpreted in a court of law, and I believe that that clarification is now sufficient for any professional advising either a landlord or a tenant in the sector to take the matter forward under Section 13 of the current Act. And the evidence that we received, in my opinion, we were not receiving evidence that was focused either at subsection 1 or subsection 4. Those subsections did not appear to be the sections of the Section 13 of the Act that are attracting concern in the sector. Where I think the division of opinion exists in the sector is the emphasis towards market evidence and such that a market exists, or is emphasis towards a budget, or is it a mixing of the two?
So what you're saying is in practice it works?
In practice it works, yes.
Okay, thank you.
Okay. Let's look at another aspect of this. Why are there apparently such differences between the rents of 1991 Act tenancies and the rents of LDTs and SLDTs?
The attraction of a limited duration tenancy is that they very often are an extension to an existing tenancy, and therefore there is the temptation to bid to secure that additional land, that additional tenancy, so that farmers have the benefits of scale. And if for example, you're a tenant of 400 acres, and 100 acre comes available on a limited duration tenancy, then the temptation would be, because of the proximity to your main holding and the desire to make better use of fixed equipment, then you may well bid a greater price to secure that tenancy than you would be prepared to agree on a tenancy in a secure holding. It's purely convener, it's purely economics, and goes back to Mr. Don's point that a farmer would make an assessment as to whether or not he could bid a higher level for a small part of land to give him the economies of scale.
So in other words, the productive capacity of that in the short term is of a higher value.
Yes, I think that's fair comment. But then, of course, well, my colleague Ian may express this better than me, but in assessing a rent review for a 91 tenancy, marriage value and the fact that other situations would be taken into account in assessing where that rent fitted into a 91 Act tenancy.
There are, Convener, a number of other points which should be considered in your question. The requirements for an LDT, or particularly an SLDT, are very different to those for a secure long-term 91 Act tenancy. Dealing with SLDT first, which is a 5-year or shorter period, then the requirements for the tenant to undertake maintenance or indeed maintenance fertiliser application to the holding are fairly limited. So the operator of the land, in practice, has less cost. So therefore he's able to bid more to get it. And the actual grain capability or the sheep growing capability of that land is probably not different, but the cost attaching to it by nature of the length of duration of the lease. Similarly, an LDT starts off with an assumption that the landlord has to put the holding in proper order. Yeah. And on the assumption that that is done at the start of the LDT, there is a considerable period over which the incoming tenant to a new arrangement under that particular situation would actually have to have very much less cost attached to his farming of that holding. And it's only in the longer term operation of a secure long-term 91 Act tenancy where the full costs of maintenance, both of the fabric and of the land itself, in terms of drainage, fencing, fertilizer, maintenance of buildings and so on. So in real, actual, practical terms, there are very significant differences in addition to those which John Ross has referred to in terms of farming one piece of land in association with another.
So I suppose I should ask at this point then, you know, given that hereditary tenants and may have been involved in the farm for generations, as the word hereditary suggests, during this time the land values will have continued to soar, perhaps to unavoidable levels, unaffordable levels for tenants, yet many feel that they played a strong role in maintaining and raising the value of the land for their landlord by their actions over a long period of time. So if that's the case, isn't it a fact that the productive capacity in a secure tenancy is likely to be maintained, whereas in an SLDT and an LDT, the productive capacity can be diminished in the process of the short duration that they are on and the limited amount of input that the farmer has to make on these. Well, obviously, if it's grazing cattle or whatever, there may be adding to the productivity of the land. But, you know, how do you make that? How do you compare these two aspects with regard to the productive capacity of the land?
I think the answer to that lies in the basic understanding of what a lease or a tenancy is. A tenancy of a piece of land is basically a business partnership between two parties to operate that piece of land. The landlord owns the land for his own particular reasons and purposes, but among those is not included farming in an agricultural sense. So he therefore takes on a tenant as a partner to farm that land. The farmer, the tenant, is interested in the business of agriculture, growing crops and livestock, and for that he needs a partner who has the land upon which he can work. And it is the nature of that partnership that defines the answer to your question. Because if it is a long-term partnership over even generations, then clearly the landlord is looking at asset value in the long term. And for that to happen, he must have a close and positive relationship with his tenant, so that the tenant is doing what the tenant possibly can do, and that is looking after the farm, both for the farmer's benefit, but also for the landlord's longer term. In other words, positive, good stewardship, if you like to use that term. In a shorter term arrangement, then the partnership is not quite as close, it is not quite as long term by its very nature, and therefore the partnership is slightly different. And where the landlord perhaps is not going to achieve the same level of uplift in capital value, then he's going to be looking for a higher rent. So it is about reflecting the relationship of that partnership between the two types of tenancy which is available.
Well, given the terms of these tenancies are so different from the SLD and LDT, from the 1991 Act tenancies, how can the rents be adjusted to make them comparable?
Convener, the adjustment of rent is a very precise process. It is important to understand the various things which make up the value of a rent, whether it is the type of soil, it is the fixed equipment, in other words, the sheds and the fences and the drains and so on that's on a farm. These must be compared one with another, and if adjustments are required, then those adjustments must be made. The same would apply to whether there are additional costs or less costs. The same would apply if there are longer-term responsibilities or shorter-term responsibilities. So it's not a question of picking figures out of the sky. It is a case of looking at what are the economics. And then adjusting, taking factual cognizance of what the difference between different holdings are. It is difficult, it is complicated. Nobody's trying to say otherwise. But the point which I think our group came to was that the alternative of going back to a purely budgetary approach was actually going to increase the complications and the scope for argument and discussion in the difficult cases, so that it would become even more complicated than the present system, which we probably understand tolerably well.
Could I just come back again there, because that's why we've been stressing the importance of the practitioner's guide, because Ian mentioned earlier it's often the process, and we heard of examples of where a rent review was being carried out on a particular farm, and the agent employed was just using SLDTs as the reference point, without anything else. And that's why we've been trying to stress the importance of getting the practitioner's guide in place that actually puts more information around what these adjustments are, whether it's the marriage value of as John described, a 500 acre and another 100 acre becoming available, how you actually adjust for that. There's also the scarcity, because there's not a lot of land actually becomes available to actually let. So there's a scarcity value, and therefore people pay a bit more. And that should be able to be calculated. And you were referring to a lot of secure tenancies where the tenant has actually made a lot of permanent improvements. Again, these permanent improvements have to be allowed for, and that's better known, in place already. But the practitioner's guide is so key to get a lot of the actual science behind how these adjustments are actually made, and that's a bit that has to be improved. And there's a lot of different information in this report, a lot of recommendations, and there's a need for a lot of action, because the actual industry isn't going through a particularly great time just now with the 2 summer seasons that we've had, the climates that we've had, and therefore a rent review not done professionally isn't good. And therefore, there's the need to take forward a lot of the recommendations in that report as quickly as possible. And we all believe that is absolutely crucially important.
I hear what you're saying, but given that we know that farmland values have risen by around 7% on average during 2012, according to Knight Frank, as reported in Monday's Press and Journal, and that that's meant that agricultural land in Scotland has now almost tripled in value in 10 years. Your arguments at being about a bad season is one thing, and we're trying to get to the issue about whether, in fact, rents could go down and can go down as well as up to meet the conditions, and that indeed whether there can actually be any proper comparison between secure tenancies and indeed said to be in an open market, which it's not, with the LDTs and SLDTs. So, land values are about saleable value, on the basis of what people will pay to get into land because of its scarcity. But at the same time, you're arguing that there is a way to measure what land is worth because it's competitive.
If I could attempt to come in firstly on the issue of comparables. We have the guidance in the Moonsey appeal decision that an SLDT and an LDT, in the opinion of the Court of Session, can be compared with a 1991 Act tenancy. Now, the adjustments that will require to be made to compare either an SLDT or an LDT with a 1991 Act tenancy will be greater than the adjustments that will be required to compare tenancies within the 1991 Act group. But I do not believe that we should lose sight of the fact that it has always been necessary to make adjustments to compare tenancies within the 1991 Act group. And variances within the 1991 Act group may include whether the tenant is an individual or whether he is a limited partnership. And a limited partnership gives a fixed life to a 1991 Act tenancy. Also, before the 2003 Act, a landlord could contract out of his obligation to replace or renew fixed equipment that was worn out. So there's another material difference in the lease terms within the group of tenancies which are referred to as 1991 Act tenancies. And the final issue my colleague Ian Duncan Miller's touched upon is you have some farms where the landlord has provided almost all of the fixed equipment and some farms where the tenant has provided almost all of the fixed equipment. And how you value the rents on those farms is the rents, albeit the farms may look the same, depending on who's invested in them, would be very different. And there is a substantial body of case law developed over a number of years as to how you deal with these variances within the group of 1991 Act tenancies. And it is my personal view that that body of case law can be developed out to SLDTs and LDTs. We've not yet had the case law as to how the variances will be played out, but I anticipate that that will come. If we then look at the second issue, which is the rising farmland market, it may be the opinion of Knight Frank that farmland is rising. My personal opinion would be that the value of farmland is not falling. And it's maintaining its value, notwithstanding the difficult weather conditions of last year. And my reason for that is if you're an investor in land, you will not look at last year in isolation. You will look at anticipated climate patterns and anticipated trading conditions over a number of years. I would suggest that if you're also an agricultural tenant or a landlord, that is the way you should approach negotiation of the rent, not at a snapshot period, but over an average period. And again, in my mind, that creates a difficulty to the budgetary approach. I'm not saying it can't be done, but it's another layer of complexity as to how you average a budget over a period of years.
Thank you very much. It's useful for us to know as outsiders how these complexities are played out in your view. We have a lot of other questions, so we have to try and get to as many of the angles on this as we can, but thank you for that series. Graham Day.
Thank you, Convener. Going back to section 13, in deciding that it did not need further amendment, I gather the group took account of what was referred to as some general observations. These included one that, and I quote, many rents are reviewed and agreement reached satisfactorily by negotiation. What evidence is there to support that? As politicians we like figures, so what's out there that backs that up?
Convener, Mr. Day, we took evidence from land agents, factors and tenants. It would be, correct me if I'm right, many tenancies are there in Scotland? About 6,000. There are about 6,000 tenancies in Scotland. The majority would be secure tenancies, but increasingly...
The 6,000 are the secure tenancies.
The secure tenancies, right. The evidence we got from factors and land agents and tenants was that the vast majority are settled. We were guarded in the word amicable, but certainly satisfactorily agreed. And indeed, it was a relatively small number that finished up in dispute. So I can't give accurate figures, but anecdotal evidence would be that the vast majority are settled without having to find other ways to resolve the problem.
But even anecdotally, are we talking about 10%, 20%? That's a problem?
Well, I would say even less. I would say
that.
even less than 10%. Well, Ian, you're...
Convener, if I could maybe put some figures on it. Over the last period of time, there has been one case which has gone the full course within the Land Court, and we all know it's the Moonsey case. So that's 1 out of 6,000, whatever. And that's one, it's been there twice, but yeah, it's been there. There are another, I think it's 23 or 24, I forget the figure off the top of my head, but it's of that order of cases which have gone to the Land Court and are currently assisted pending further discussion. Now, how many of those will finally go the course, we do not know. There is one currently being heard within the court, which is a small case. It demonstrates why it's the process that's wrong rather than the actual formula. Where I understand it's a fairly small farm, it's being heard in the Land Court as we speak, perhaps not today, but in the current period. And the difference between the two parties, I understand, is less than £1,000. Now, these two parties, with all due respect to them, are probably not going to agree which day of the week it is. Never mind how they're actually going to sort out the rent. And I don't say that with any disrespect, because when you go and employ lawyers for a difference of less than £1,000 over a 3-year period, I'm sorry, that's not sensible, and we don't need to change the law for that. We need to change the process. And so the total number of cases which are involved, yes, the Land Court is there, and yes, there's got to be a backstop to force people to actually come to an agreement. But at the end of the day, virtually all, bar 20 out of 6,000. And bear in mind, we're taking over several repeats of a 3-year cycle, so it's actually not very many.
Could I just follow that up? Bank of Scotland, in their annual survey on agriculture, is actually also putting, some percentages on, the number of rent reviews that are carried out without any issues, and that has just been issued about 3 weeks ago, and that is actually showing a high percentage that that the negotiations have gone through fine.
If I can just come back, Convener, again to the Chairman. As I understood your opening remarks, you were suggesting that there is perhaps a disparity in the level of dispute that arises where, between where it's almost an internal review that takes place with a factor who's involved locally and external factors, land agents, whatever. If that is the case, what is the sort of disparity level? I mean, from the evidence you took.
I think what you mentioned there was where there's a resident factor or negotiation taken place for some years, it worked well. I think that's because of the relationship that's been built up, over the years. When you get an outside agent coming in, then there's no relationship, and like I said, some processes that we've seen weren't satisfactory, and that's why the actual way a rent review is carried out, because there's no literature at the present moment for agents to actually follow through how a rent review should happen, how it should take place. That's available in England for both the 1986 tenancies and the farm business tenancies, how a rent review should actually be carried out. And that's why we've stressed the importance of getting that in place, so that there's something that if there's a dispute starting to appear, then both sides can actually go back to the actual practitioner's guide, how this should actually happen. Right now, there's nothing, and that's why we feel that it's really important to get that put in place. And, just some timescales around, when things should actually happen, rather than, if a rent's due in November and discussions only start in October, where we saw examples, to get some timelines around, what should happen in the 12 months before the rent should be agreed.
Thank you for that.
Okay. Did you want to say something, John?
Briefly, Convener, I have in front of me the letter that I receive from one of my landlords, and if you're not aware of the process, then this is a letter which causes you concern, because it says, being the next ensuing term at which the trustees could terminate a tenancy by notice to quit. Now, if you're a tenant and you're busy farming, and this lands on your door, then you think, goodness me, what's the next stage in the process? But this particular landlord then sends a letter in the same envelope, which explains that this is a statutory notice, and then explains to me the steps that will be taken in the expectation that the rent will be agreed satisfactorily. And I think that's been missing in some of the ways in which the notices are served without an explanation, and that's one of the recommendations that we strongly feel should be brought in. There should be, if you like, a layman's guide as to how the process should go from the receipt of that letter.
Okay, thank you. Jim Hume, carrying on with that.
Yes,
Vein,
carrying
I
on
think.
with that, and I should maybe declare a farming interest, or remind members that I do have a farming interest. Just going back to any adjustment of Section 13 of the 1991 Act, yourselves recommended that there shouldn't be any amendments to that, but of course the judgment on the Moonsey case was very critical of that, the drafting of Sections 13 of the Agricultural Holdings etc. Act, saying such things that a literal reading of subsections 13.3 and 4 would produce an absurd result, and it calls the draftsmanship of the amended section inept, which is quite strong words. Given all that, what was the thinking behind the conclusion that that section did not need any further amendment?
I think the view is that, albeit the drafting of those sections was heavily criticised in Lord Skill's judgment, he gave an explanation as to how he saw those sections operating going forward. And within the sector, I have not seen, and within the evidence that I've received, I've not seen a lot of evidence saying that the sector has ongoing concerns relative to the operation of subsections 3 and 4 as now interpreted by Lord Gill through the Moonsey judgment.
And if I just may follow on just regarding the Moonsey case, again, but a slightly different point regarding it, the fact that the single farm payment is allocated on an historic base seemed to be important. So we're now moving, of course, with CAP reform from a historic base to an area base. How relevant do you think that will be?
I think, Convener, Mr Hume, the answer there lies in the operation of the market. The farmers themselves will work out the various incomes that they can gain from farming a piece of land, whether that be by production of stock crop or by the gaining of subsidies that are available to it. And I think the point of the Moonsey judgment was that already happens, and the first decision of the court was overturned by the Court of Session, and that was the judgment which obviously eventually held sway, and that relied on the fact that the farmers were taking all these things into account in reaching their decisions on what they can make from a piece of land, which is why we take the view that actually if you take the market operating in its widest and best sense, then the market will tell what the appropriate rent for a piece of land is, taking into account whether it's subsidy, whether it's farming interest, whether it's diversification or anything else that could be gained from it. Whereas if you take a purely budgetary approach, you've then got to take account of each individual element in the way that you suggest, and to almost enshrine that in law, which becomes complicated beyond belief and would lead to arguments which are far greater than you would have in actually going through a fairly clinical process of comparing the various aspects that make up rent.
That's
Okay, thank you. Just a couple of points on these general sections. First of all, Claudia Beamish.
Thank you, Convener. Could I take you back, please, just to the comments about the secure tenancies, the 6,000 secure tenancies, how it's only a small minority, which you have highlighted that there are concerns in relation to dispute about. Did you find any evidence in your taking of evidence from tenant farmers of a concern that they couldn't go forward towards the land court because of the costs? And that's something that has been highlighted to me, or other concerns in relation to the relationship with the landlord that might prevent them pushing on the negotiations. Was there evidence of that?
I think you're absolutely right. You know, in what you say that, you know, there were concerns about, you know, the cost of the land court route. On the plus side, there was the trust in the land court compared to what we'd had before with, you know, the arbitration process. So there's, you know, the move to the land court, there is a definite feeling of trust in that process. But as well as cost, it can be a lengthy process, a long process, and sometimes you almost get into another rent review before the previous one has been actually sorted out. So there's definitely, you know, and that's why we tried to, you know, and we did spend some time with land court, you know, members and people, you know, trying to find ways of how you could actually streamline, you know, the land court process if it did land in the land court. Because all our thoughts are, you want to try and avoid getting to the land court. You know, all the different things we've recommended is try to avoid getting to the land court, but you need it there as an end point. So the case management, and I think there are opportunities to actually, you know, smooth, you know, the process through the land court, and maybe John wants to, you know, to mention part of that. And I think, you know, even in the land court itself, it's, you know, because they've seen this, and you know, they believe that there are opportunities to, you know, to make moves forward as well.
I think the cost and potentially the effect on the parties' relationship should a rent review be taken to the land court is a concern for tenant. I also consider it's a concern for landlord, and it has to be a reasonably significant farm in Scotland, in my opinion, for the parties to be £10,000 apart on the rent. And sadly, if you run a Moonsey type application through the land court, irrespective of which side you win or lose on, the financial professional costs and the emotional drain on both sides will far exceed the benefit. We have engaged with the land court. The land court has stated its intention to operate as a court and has given guidance on past decisions on that, and that's within the land court's decision. There was a view among some when the 2003 Act was introduced that you simply required to approach the land court and ask them to tell you what the rent for a particular farm should be. The land court considered that proposal and stated that was not the way it was going to operate. However, there still, in my opinion, is within the sector an appetite for that outcome to be delivered, and the group's proposal as to how that outcome might be delivered is through expert determination and formation of a panel of experts. And really, parties' views on that would be the parties would require to agree what the farm was, the basis of its occupation, and who had provided what fixed equipment. But if that expert determination form of alternative dispute resolution was created, then the parties would put their trust in the expert to go away and come back and simply tell them what, in his expert opinion, the rent should be. And in my opinion, that gives a summary but cost-effective way of solving the rent dispute. And the risk to both parties is, if you don't like the result, you have to live with it for 3 years until you're entitled to review your rent again.
Convener, could I maybe add an additional point? I think that there's an important element in here as well. Very often, all that is in dispute is the quantum of rent. And where that is the case, then a reasonably straightforward arbitration or expert determination is simple and not a problem. We should not confuse that with the likes of the Moonsey case that took the headlines, where there are some very complicated, or there were some very complicated issues of law involved also. And the court's role in that situation was to resolve them prior to resolving the rent. But bear in mind that Section 13 is actually about resolving the quantum of rent on a farm, and other questions of law are covered elsewhere in the Act, and our brief was looking at the actual mechanism for the quantum of rent.
Can I just ask a question while we're thinking about the land court? Can it say to the parties, look, we're not having a recess to go into this in more detail. We're going to get to a decision, you know, quickly. In your discussions with the land court, did you express the frustration that people have because many will not go there because of this threatened cost? That in fact, the land court should be doing more to make sure that the parties get these things sorted out very quickly.
Convener, you're absolutely right. We did, you know, mention that, you know, to the land court, you know, when we had meetings with, you know, different people in it, and so that was definitely, you know, put to them. There's no two doubts about that.
What's the response?
I think there's areas, you know, that are included in here, you know, where the land court, you know, would be happy to, you know, to work with TFF to, you know, to move things forward.
My opinion is there's a spectrum of outcome. My opinion in the dialogue with the land court is they will be more proactive and they will be more interventionist with a view to speeding the process of a land court application to fix an agricultural rent through the land court. But they will not take the step of going to a completely expert court. And by way of example, Party X comes in and says the rent should be £10,000, Party Y says 15, and the land court discards the evidence of both parties and I think states the rent should be somewhere else. So they're still in the position that they are mediating between the evidence of two competing parties.
Okay. We'll reflect on your remarks just now for that. Did you have any other points, Alec Ferguson, on the arbitration side of things as an alternative?
Not yet, but I might come back.
Okay.
At the end, if I may.
Yes, sure.
Sorry, I've got points on arbitration, yes. Do you want me
because that was
to raise that just now? Yes, okay.
On, yes, the expert group.
Yeah. Yes, I'm happy to raise that just now, convener. Thank you. Arbitration, I just wanted to have a quick look at the arbitration and what you called expert determination in the report. And I was particularly interested because I mean, the 2003 Act allowed for the continuation of arbitration, and I think I'm right in saying that the then Scottish Executive spoke of doing away with it altogether and transferring all dispute resolution to the Land Court, and by what we've been hearing about this morning, it's probably a very good thing that that didn't happen. But Henry Graham, I heard you in answering to Claudia Beamish saying that trust, the plus point of the Land Court was that there was considerable trust in it. And I think you actually went on to say, unlike the arbitration process, which gone, and I'm therefore interested in why you are actually recommending greater use of an arbitration process, given that you also sort of highlighted the fact that I guess particularly the tenants didn't particularly trust that process.
Could I maybe convener? Could I maybe just kick that question off first? And I'm sure Ian wants to, you know, to come in on it as well. What we're recommending on the arbitration side of things is very much between valuers and arbitrators that are in place. They've been moving forward with a short form arbitration process, which is actually different to what was there before. So we haven't spent a huge amount of time, you know, on that, because anybody we talked to were happy with that short form arbitration, that this was a move forward. And, you know, that's where, you know, both sides can agree to, you know, arbitration. But different to what it was before, you know, the recent act. The expert determination is, you know, is an alternative route as well as the short form arbitration. So we're not, you know, saying one should happen or the other should happen. We'd like both to be taken forward because we believe there's a route for both. Ian, do you want to follow that on?
Convener, if I could, I think it's if I give it a bit of history to this background. Prior to, well, go back into the 80s and 90s, arbitration was run by what was known as the Secretary of State's panel. And the appointments to that panel were because you were a fine fellow and true and carried respect of your peers. But unfortunately, that respect did not always carry with it the professional ability to carry out an arbitration properly and correctly. As a result of that, a number of arbitrations became as costly and as lengthy as the Moonsey case itself. And through that, generated distrust in the system. Since then, we have got the 2010 Arbitration Scotland Act, which has set out quite clearly and properly how arbitrations can be carried out. And in conjunction with that, the professional body, the Scottish Agricultural Arbiters and Valuers Association, have started the process of professionally qualifying people to be qualified arbitrators with CPD to match, so they actually understand the current process to operate that within the confines of the 2010 Act. So the world has changed and moved on, and the 2010 Act, together with the panel of professionals who are qualified and who have continuing CPD, is a very different scenario to that which was there previously. And it's against the current capability that we think that arbitration has a positive role to play in sorting out rents in today's climate.
I'm delighted to hear that, and thank you for that very clear explanation. Just one other point I wanted to clarify was that I think I'm right in saying in your recommendations you are suggesting that there should be no appeal against the determination as arrived at by an arbiter or an expert determinator, if that is the correct thing, unlike any process through the Land Court. And I just wondered if you could talk us through the rationale behind that.
I think, again, come in, or maybe John as well, but with the arbitration, the short form arbitration, there's still an appeal procedure, after, with the short form arbitration. Expert determination, there's no appeal. So, that's the opportunity to make it, speedier and efficient. But again, with both arbitration and expert determination, the need for training and for the experts, arbiters, to be actually meeting regularly to to exchange views on how rent reviews have been actually carried out, how rents have been determined, what level of rents have been determined, so that you actually get the knowledge transfer between the experts and the arbiters, just in the same way as the rent register. So that there's slightly different animals, if I'm right. You want to follow?
If I could possibly amplify, Ian's history is correct relative to the sweeping away of statutory arbitration in the 2003 Act. Your primary dispute resolution forum is the Land Court. You can only opt into an alternative dispute resolution mechanism after the dispute has arisen and by agreement between the parties, so neither party can force another party into ADR. With the introduction of the Arbitration Scotland Act 2010, subject to minor legislative change to align the Agricultural Holdings Act with the Arbitration Scotland Act 2010, because there's a couple of tensions between the two acts at the moment, I think the Arbitration Scotland Act 2010 gives a potential platform for rent disputes to be settled in Scotland. And I say it's a potential platform because the product will have to be developed and the market will require to be given an opportunity to use that product or not, and it will either succeed or fail. Within the Agricultural Holdings Acts just now, there is a statutory right of appeal from an arbiter's award to the Land Court, which cannot be contracted out of. Some evidence that we received from parties within the sector was if they went to an arbiter, they would want that decision to be final, and our recommendation therefore is to make the compulsory right of appeal an option, and then parties would have a decision whether they wanted to retain the right of appeal or waive it. Expert determination is much more commonplace in the commercial sector than the agricultural sector. My simple view is if you can use an expert to settle some of the very expensive rents in office blocks in close proximity to this building, it should also be possible for an expert to settle rents on a farm. And the general rule is that a decision of an expert is final and binding on the parties without a right of appeal. But parties exercise that judgment and are prepared to take that risk when they appoint an expert.
So that's going back to Claudia Beamish about the cost, of the land court, whereas, the short form arbitration or expert determination takes a lot of cost out.
I have to say, I'm very, very grateful for that explanation. I'm not at all surprised I was confused. I'm less so now, thank you for that. But can I just finally, Convener, if I may, you mentioned the potential within the 2010 Arbitration Act, coupled with the Agricultural Holdings Act, with a bit of fine-tuning, I think. But you did mention there was that as a potential platform for dispute resolution. Are you putting that forward as a desirable option and a potential way forward in all of this?
I personally and the group support the development of arbitration and the development of expert determination as alternatives. The litmus test will be, if these alternatives are created, whether the sector buys into them, because there will be alternatives that the sector have to opt into. But the evidence that we received suggested to me there is some appetite to try these alternatives if the product exists.
Okay, thank you very much.
Thank you. Jane Baxter next, please.
Thanks, Convener. Morning. A note in your recommendations that a voluntary rent register should be established and maintained to improve access to comparable rents. And it seems to me as a layperson that can only lead to better informed decision making, which is a good thing for everybody concerned. But my question would be, why is there apparently such a scarcity of this information at the moment? And who would develop and keep a register of comparable rents? And who would supply details of rents? Would that be the landlord or the tenants?
Well, I think in answer to your first question, the farming community is relatively small, and not every farmer would want to disclose the agreed rental that he'd made with his or her landlord. Some farmers would say he's paying far too much, and others would say, how on earth did he manage to negotiate such a small rent? So there's a question of confidentiality, and that's why we would have, we came to the view that it should be a voluntary rent. It should not be compulsory for every rent to, at least at this stage, to be recorded. With regard to who would keep the register, well, it would be awfully convenient if it was the Scottish Government that would keep it, but we were aware that might not find favour with your good selves and others. But the professional bodies could actually would be capable of keeping that register. But I think going back to the previous point, where expert determination could be a route, and my colleague Ian has said that in order to be party to be one of the people who would be an expert, there would need to be meetings and CPD, so that there would be a good informal understanding of how rents were going in different parts of the country.
Could I just follow that one up because we didn't want to to be definite in where that rent register should be held. We wanted to keep that open because there might be within government like the Fair Rents Office places that might want to hold that information. So that's why we were weren't saying definitely it should be held in a certain place, to give the opportunity to to look at where's the most the most sensible place for it to be located.
That's helpful. Thank you.
Okay, thank you. Let's move on to one or two other areas that we haven't covered yet. Particularly, Dick Lyle, was there anything further you wanted to ask about?
Yes, Convener, thanks. Good morning, gentlemen. Can I say that looking at your qualifications, they're excellent, but and the point that John Mitchell was making earlier about negotiation and valuation, how do you feel about, and I'll come on to the black art shortly, how do you feel about the reaction to your group report? Scottish Land and Estates news release welcomed it. The NFUS has voiced disappointment at the group's conclusion. No further amendments to the law. Scottish Tenant Farmers Association has criticised your rent review group's report. and it calls for a fairer deal for tenants. News release actually went on to state that the RWG report has failed to recognise the dangers of an open market-driven rent system which depends on what the group's chairman, I'm sure you'll likely regret making those words, referred to as the black art of valuation. Turning to that, is the valuation of rent of a farm a black art? I don't think it is, but anyway. What is the problem with using the open market as a benchmark for rents? The point made earlier on, that most valuers look at what it can sell for, what comparable rents are, etc., and generally sit down and agree. In my experience, so where does the black art come in? Do you think of the first number you thought of, double it, half it, X, Y, Z? What is the black art?
If I kick the answer to that question off, and maybe one of my valuation colleagues will come in behind me, I think where the black art sits are in the valuation notions of scarcity and marriage value. And in the past, it would have been sufficient for a chartered surveyor to giving expert evidence to say, in my opinion, the open market rent, which is probably LDTs for that type of farm, is X. This is purely an illustrative example, and don't hold me to the figure, but using my expert opinion, I consider that I would deduct 20% from that open market figure to adjust to a 1991 Act tenancy. So I think the comparable rent for a 1991 Act tenancy farm is open market less 20%. Where we have the difficulty just now is that subjective opinion is no longer sufficient for the courts, and they require a repeatable methodology as to how that expert surveyor exercised that judgment. And it's my opinion, and I think the opinion of the group, is it is not well documented at this stage the repeatable methodology that one applies when making that adjustment. And it's my position, I think also the position of the group, that if we can, through the professional bodies, document that repeatable methodology in a way that the professionals adopt, and then subsequent to that, put it in layman's language that the tenant farmer can read and understand, that will take a lot of the tension out of the rent review process. And I think the reference to black art is, it's because you can't pick the valuer's manual off the shelf just now and say, this is how it's done. And if you can, in the future, pick that valuer's manual off the shelf, then the black art element falls away, and hopefully some of the difficulties that exist within the sector at the moment fall away as well.
Any of the panel disappointed with the reaction you got to your report? Taking on board the wide experience that I'm seeing this morning, right across the board.
Disappointed but not surprised, because there were fairly strong views from various bodies before we started this exercise, and I think in particular NFU Scotland has landlords and tenants as its members, and therefore has to try and make sure that it steers a fairly neutral course in satisfying the expectations of a fairly wide diversity of membership. So the answer would be disappointed but not entirely surprised. That would be my personal view. I think perhaps my colleagues would agree.
Graham Day wants to come in on that.
Just a small supplementary, if I may. It would appear from the point that my colleague Mr Lyles made is the tenants are unhappy with you, essentially. the STFA, and there's obviously a tenanted element in the NFUS. How do you react to that? Do you accept that perhaps the tenanted sector is the issue here?
I think we have to recognise that there are 6,000 tenant farmers in Scotland, and yes, and that the SFDA, I think, has 600 or 700 members. So it's a relatively, it's a very vocal, and I'm very happy that it's good to have a diverse opinion. But I think it should not be taken as the view of all tenant farmers. It's those in specific who've got specific issues.
Convener, if I could maybe just add a supplementary answer, perhaps back to Mr. Lyle's point. When we received evidence, we tried to analyse and evaluate that evidence. We got evidence from the STFA and indeed from the NFU team that they were wanting the productive capacity of the holding as the basis for evaluation of rent. So we did actually look at that, and we did evaluate what would that mean. And we've got to start off with the assumption that they were putting that to us on the assumption that it would benefit their members. But even with that assumption, we still challenge in our own minds, what does that evidence actually mean in real terms? And if we, as we did, we follow that process through, we found by looking at farms under hereditary tenancies on either side of the border, to the south under the 86 Act, which has this particular formulation within the Act, and on the north side of the border, which has the 2003 Act that we've been discussing. And we find that actually the rents south of the border were, on balance, marginally higher. If we then looked at the Moonsey case, which is very much in the public domain, and say if we applied a budgetary formula, as the Scottish Land Court did in their first decision, and looked at how that would then repeat sometime later, we would find that in a 3-year period, the rent of that particular holding would have, using the same formula, regardless of whether that formula is right or wrong, but if you accept that that was a formula at the time, 3 years later, the rent would have increased by a factor of 3. Now, I don't think that would be a sensible way to put a new formula for calculating rent into place where you get this extreme hikes and downs in the value of rent. It would seem to us more sensible to actually have a steadier progression, albeit that the rent tends to follow rather than lead the economic conditions of any particular sector. But that would seem to be a more sensible way for the market to actually evaluate what's going on. So we did look at very carefully what the STFA and others said to us and evaluated it, and we concluded that actually had we gone through what they had said to us and come out with that set of proposals as changes to yourselves and others, that actually it would not have had the effect that perhaps they themselves were looking for.
We just follow that up, convener, by saying that we were asked to look at what's a fairly complex subject, and none of us have any axe to grind. We're trying to be as professional as possible at looking at what we were being provided with and analysing it and trying to be as professional as we possibly could to come forward to yourselves and to TFF with what we believe is a recent judgment, and also with some real recommendations that still require a fair amount of work to be done on them. And that's why I keep stressing there's work to be done on these, and it's important that that actually happens.
Okay, thank you. On these points, I'm not stealing anyone else's questions, eh? Right. Claudia Beamish first, and then Nigel.
Could I ask you about what you have already touched on, Henry Graham, in previous questioning, about the Guide for Practitioners, which seems from the discussions we've had this morning to be emerging as quite fundamental to the process in terms of the consistency of methodology. Possibly also from the suggestions of some that I've seen, it's also important in relation to making sure that geographically that there is consistency. And I wonder who would be, who in your suggestion, if you have views as to who would put this forward and how it would be developed and who would be responsible for it.
Well, we've we've come forward with, our recommendations to both TFF and the Scottish Government as requested. So therefore, it's, we can only recommend, what we believe is important. And it's important that TFF, with the different membership within TFF, that they believe that this is the right way to, to go. And I think that, I think, because most of the things that we've suggested, there's been consensus anyway. And therefore the practitioner's guide, as you mentioned, is actually key, to a lot of the rest of what we're talking about. And I believe that through TFF and with Scottish Government believing that's important, that the professional bodies will take that one forward.
Convener, if I can maybe add to that there is a precedent as to how this might be handled. South of the border, the Central Agricultural Arbiters and Valuers Association, CAAV, have a booklet which is about yay thick, which covers precisely these points. So there is already a template there, and if that is adapted for Scottish conditions and Scottish law, then it can be done, I think, reasonably easily and quickly.
You'll understand that, we've heard about voluntary codes and all the rest of it in other contexts, which stretch to hundreds of pages. And the difficulties of getting anything which is a voluntary code applied when it's at that length is very difficult indeed, unless there's some statutory underpinning. And I can understand where Claudia Beamish is coming from in this question at the moment, that it might be unsuitable to people to have to think about it, but in fact, we know how voluntary codes don't work.
I think at the moment, Convener, is if an agent is asked to review a rent on behalf of his client as a landlord and goes to see a tenant farmer and they have a conversation around the kitchen table, there is nothing by which the tenant farmer can then judge what is being said to him. If he is aware, either party is aware of what is within the code, and the person across the table is perhaps trying to pull a fast one, or perhaps conduct things in a different way, then place the code in front of them on the table and say you're not following that, and that should, in most cases, bring the conversation around the table back on to the agenda. If it doesn't, the same problem will exist whether it's a statutory code or a voluntary code. How do you then start reporting procedures against the person who you're not happy with, and how do you put that right? Do you go back to his professional association, the RICS? Do you go back to the Scottish Land and Estates? Do you go back to the STFA? Those issues and questions are not necessarily of themselves resolved by having it as a statutory code or a voluntary code.
Well, if it were a statutory one, it would have to have a means of resolution, or it wouldn't be worth the paper it was printed on. Indeed. Okay.
Thank you, Convener. It's a specific and different question. It may not fit with the context of your review, so I apologise if it doesn't. But, and it is sub judice. But could I ask whether there's any comment from yourselves about the Salveson Riddle case, which, as you will know, is the Scottish Government is taking forward in the context of this review? Right. Thank you.
Just go back to the earlier point though, because I think that's quite an important one, and we constantly believed that what we were suggesting, if we could make it in such a way that the industry felt they could support, then it was far better for it to to be industry wide voluntarily compared to us bringing in sticks to make it happen. So that's exactly the same with the rent register, as well as what we're talking about just now. To try and make sure that the industry in total wanted these things to happen.
Okay. Thank you, Nigel.
Thank you. Can I just come back to to something which I think was mentioned very early on, which was that some of these rent reviews have been delayed. I get the impression that the current process, and possibly what you're suggesting for the future, is to some extent biased towards the landlord, and I don't want to use that in too pejorative a way. Simply that if economic circumstances aren't good and seem to be getting worse, then he can simply effectively delay the review, such that a falling rent doesn't appear. and can carry on with the current rent until it turns out to the landlord to be convenient to have the review. Am I overplaying the case? Is that fair?
In my opinion, yes, you are overplaying the case. In agricultural tenancies, specifically 1991 Act tenancies, you have a statutory 3-year review cycle, and either party, landlord or tenant, can serve the notice to review the rent. So if you are in an economic situation where rents are declining, yes, the landlord may choose to do nothing, but the tenant can preempt that by serving the notice to review the rent, and in those circumstances we'd be seeking a downwards adjustment.
Would it be fair to say that history suggests that some tenants might be reluctant to do that for personal relationship circumstances?
We did have evidence from one landlord where they had agreed a reduction in rent because they felt that the rental had been set at a level which meant that the farmer was likely to not be able to sustain his operations. And so we did have evidence, certainly of one rent, that the landlords had decided to reduce it so that the tenant could continue to operate satisfactorily.
Forgive me, I find that very encouraging, but the world, as we see it, I think from here, divides into the very large majority who try to do reasonable and sensible things out there, and the small majority who, the small minority who take advantage of their position and for whom we have to legislate, actually. So we're always dealing with that obstructive minority because most people will look after themselves. So I still come back to the basic point. If a tenant feels that they are disadvantaged, they might not want to press the opportunity to have the rent review. And I'm just wondering whether you feel that's something that does happen. And if it does happen, what might we do to better the situation, please?
Convener, Mr. Don, I think taking our report as a whole, we have looked at the way the process works. We've also looked quite clearly with some good recommendations, I believe, on dispute resolution. Where the dispute resolution process is simpler, easier and cheaper, and therefore more open to anybody to take part in, then the tenants could quite easily, I think, take more advantage of that. There will probably be some situations where tenants would feel awkward in serving notice on the landlord. I quite accept that. But I think we've also got to be aware of the history, where we have seen agricultural inflation, and by that I mean the inflated values of agricultural inputs and outputs, has been moving ahead quite steadily since about the mid-80s anyway. And over that period, there has been an upward rise in most of the values associated with agriculture. If we were to enter a period where these things were going the other way, then with a simpler and easier and more effective dispute resolution process, there is absolutely no reason why the tenants could then say, the market is moving a different direction now and we need to review rents and adjust them downwards instead of upwards.
Just reinforces what I've heard as a central argument, which is this is all about process.
Yeah.
And if we can keep that simple,
yes, yeah, absolutely,
well, we can make progress. Thank you.
Alec Ferguson wanted to point that. Yeah.
Well, I simply wanted to put on record, Convener, that I am not one who believes that the legislative route, the statutory route, is necessarily the right way to go, possibly for the simple reason that as soon as you make something compulsory through legislation, it seems to me that the lawyers then go out of their way to find a way round it. And I think that is as true sometimes in agricultural rental holdings legislation as it is in any other form. But I can see that as a backstop it might have to be the case. I just wondered if I could put a sort of general point to the board. I mean, we've all been pretty polite this morning about some of the stuff that's been seen in the press and some of the stories that we've heard. And some of the reading has not made happy reading for anybody on either side of this argument. I've always believed, we've been talking about landlords and tenants effectively, but I've always believed there's a third partner in the equation, and that is the land that is actually being farmed and the good of the land that is being farmed, because land is not a short-term commodity, it's something that has to be looked at long-term. Can I just ask generally, given that some of the unpleasantness that we've seen in the press, and I can understand why it is there, do you believe that your recommendations, if carried through, would significantly reduce the level of, I'm sure the answer to this is yes, because it is about dispute resolution. But do you also believe that the current trend towards effectively short-term rental agreements is good for the land that is being farmed.
Mr. Ferguson, Convener, I think we genuinely believe that the recommendations we're putting forward for greater transparency, better understanding of how the Act operates, and with a code of conduct that would see land agents and factors and tenants operating, in a correct manner. That will, I would be disappointed if that did not see the small number of cases where there is dispute diminish. So I genuinely believe that with the Tenant Farming Forum now pressing ahead with implementing those particular parts of our recommendations, then I would hope that the reports in the press of difficulties between landlord and tenants would diminish. It'll never disappear, but it should diminish. With regard to the wider issue you raise on short duration, limited duration tenancies, well, it is a major commitment for an owner of land to let that land on in perpetuity, because one never knows when land has to be sold or when it has to be retrieved. I think the benefit of the short duration tenancies is that the landlord is required to put the fixed equipment in very good order and be suitable for how this land is being farmed. So I'm not persuaded that this would be detrimental to the long-term viability of that land, because it gives landlord and tenant the option to review whether or not this business arrangement actually continues. And I think looking at the world food, the actual desire now that land must be used to produce food, there will always be that land is likely to be tenanted and farmed effectively, even if it's on a shorter duration tenancy. And it certainly is significantly better than the mechanism that was used to circumvent security of tenure through partnership arrangements. That's out with our rebit.
I'm quite surprised the convener allowed the question, because it is completely out with the rebit. but I'm grateful for the answer, because I think it is quite important.
We do have to meet the. I was alluding to that at the beginning when I was asking about the productive value of land as well, and I think it's important when we meet the stakeholders as well in a fortnight or so's time. So that's fine. We need to move into one or two other points, and it's the next one. I think Graham Day wants to ask about hotspots.
Thank you, Convener. Gentlemen, from the evidence that you received and your own clearly extensive knowledge of the sector, I'm wondering, are there particular areas of the country where rent reviews tend to be contentious? And if so, where are these?
I have a first shot at a contentious question. The information that we received, as I said right at the start, that rather than geographical, it's where the resident factor was in place and good relationships had been established over some period. There were some examples, even with resident factors, where a rent review hadn't taken place for a number of years. That relationship had actually waned a bit, because it's a rent review that tends to bring the landlord and tenant together, and the factor. So therefore, I think rather than geographical, it's round about, is that relationship, strong, or is it not? Where the relationship is poor or weak for some reason, and it doesn't need to be around a dispute, it might just be time. I think it's more around that relationship rather than the geography.
So you don't accept the STFA's description of hotspots in Scotland for this issue?
But that might be the case because there might be hotspots because of that.
To that.
Yeah.
So you don't think that there's a difference in the way that tenants on islands like Bute and Isla see themselves in the geographical sense that fits into this discussion about hotspots?
But again, these are examples where there's probably a professional agent being brought in, and therefore, the relationship that I've already mentioned isn't nearly as strong as where there is a resident factor. So it's back to, I think it's back to the actual relationship part, and it might be that where there's landlord tenants on remoter areas, they have a more distant relationship than one where the factor is actually living, in amongst the tenants.
I understand that, but I mean, people who live in islands often tend to be as indigenous as some of the stock that they are breeding and so on, because they are islanders, and that's one of the reasons why the hotspots thing can be geographical. People move in and out, but there's still a core of people who are islanders and see themselves under particular pressures because of that.
Could maybe answer that in terms of the evidence which was led to us. Clearly the personal relationships are important, and I don't think that the tenants in islands, as you suggest, see themselves differently to tenants in other parts of the country. But I think the personal relationships are the key difference. And as Henry Graham has pointed out, in some of these island estates, they have parachuted in external agents to negotiate the rent. And clearly that has immediately put considerable tensions on the interpersonal relationships during that process. And in some cases, it is fair to say that the evidence we received was that the conduct of those discussions would not follow any textbook that could ever has been or would be written. So that is why we come back again with the suggestion that there be a standard format, and that at the outset of the discussion, all the facts concerning the case of that particular farm and its rent be put on the table so as to diminish the areas of difference or discussion, if you like, so that people can actually start off and say, well, this is the benefit, this is the farm, these are the terms of the lease, these are the terms of the post-lease agreement. And the conversation on the rent goes from there, rather than these facts coming out piecemeal and the parties playing games with each other, because that just simply doesn't work, and it has to be said that that does happen at the moment.
Just to give an example of that, we did have evidence from, from I think it was Islay, where a rent review was taking place, and the comparables was an arable farm in the Borders. So, that is, the actual process being wrong and how it was carried out being wrong.
And the process, we did hear of circumstances where the process was the tenant got the letter a year before, you get a year's notice of rent review, and nothing happened until, 2 weeks before the date when notice to quit could have been handed, and that put the tenant under enormous pressure to agree whatever rental the agent wished to take, and our code of practice and our layman's guide should actually address that particular issue.
Angus MacDonald, want to follow up on that point?
Yes, thanks, Convener. I'm picking up on points that have been touched on earlier. I've got two parts to this question. I'd be interested to hear the panel's views on the STFA's call for a code of practice for conducting rent reviews, and for there to be a complaints procedure. And picking up on the outside agents point, I'd be particularly interested to hear your views on how the RICS operates. And would you say, for example, that the RICS code of practice is fit for purpose? Given that, well, the reason I ask is that I believe the current code of practice weighs a ton. And assurances were made to this committee that it would be made into a more manageable document, which doesn't seem to have happened, at least as far as this committee is aware. So I'd be interested to hear your views on particularly on the RICS Code of Practice and the STFA's call for a Code of Practice and a complaints procedure.
Convener, Mr MacDonald, the RICS Code of Practice does not of itself cover the process of rent review. It covers the conduct of members of the RICS in their dealings between their clients and the respective people they do business with. What we have suggested in our report is that there be a clear guide that all parties can follow in terms of the actual process of reviewing a farm rent, which is a slightly different issue.
So, have you set a timescale to have that in place? A suggestion?
Well, yeah. There are two issues to timescales. One is the timescales of the process of review itself, and in terms of getting the code of conduct into working practice, as Henry Graham has said, that there is work to be done to bring this forward urgently. We are already into the time period for the detailed discussions on reviews to be done in May, and very soon we'll be into the period for detailed discussions to be done in November. And we're suggesting that these discussions, at the very least, should open in earnest 6 months before the actual review date. So if this is to be in process before the November reviews are to be carried out, then we need some fairly urgent action. And I think the TFF are aware of our concerns on this matter.
Okay. Well, that's good to hear. With regard to the complaints procedure, what are your views?
Well, clearly there has got to be a way of getting complaints addressed. At the moment, it would be a complicated process if it was a member of the RICS through them, or any other professional body, including, I think we should be clear, this isn't just about complaints addressed to one side or the other. There are as many difficult landlords as there are difficult tenants, as there are difficult agents in the middle. So I think whatever process we have there should be equally applied to all. And at the moment, it is quite difficult for, if you take the example of a RICS agent, then clearly there's an RICS body and one could take a professional complaint against them to that body. What would be the effect of somebody saying that the tenant was being unreasonable? If you took a complaint to the STFA, he may not be a member. Likewise, the Scottish Land and Estates. So I think there are some issues to be sorted out within there in terms of a complaints procedure. But it is our view from the evidence led to us that if there was a written down methodology of going through the process of rent review, then more parties, perhaps not all, but more parties would follow that in an organised and sensible fashion. And that would be to everybody's advantage.
Thank you very much for all of that. It's given us plenty of food for thought. I'd like to thank you, gentlemen, for indulging us with some of the experiences you've had in trying to reach your proposals. And we may come back to you with some further questions on reflection, but it's very helpful to us when we speak to the stakeholders, as I alluded to earlier on. So I will close this part of the meeting publicly. Thank you for being able to be here to be witnesses, and we will move on to the next item in private in 5 minutes' time. Thank you.